It's time for story time. This client was a foreign tax resident. He had an Australian trust, which owned his company that ran his business. This dude was going to sell the company for a lot of money. Trouble is, capital gains going through Australian discretionary trusts have a big problem. If you're familiar with the Greensill family, specifically Lex Greensill, he was the star of a tax case, and that case basically said a capital gain coming out of an Australian family trust to a foreign resident gets a 0% CGT discount. So it taxes the gain at 47% effectively. That's bad. So I said to the client, look, you've got three options. Number one, you can pay 47% tax. Number two, you can distribute the capital gain to a corporate beneficiary, pay 30% tax, and then pay a dividend to yourself, and that's a final tax as well. Or the most risky strategy is we can convert the family trust into a fixed trust and pay 0% tax. The 0% tax strategy has a lot of risk. The ATO is going to hate it. However, it's perfectly legal inside the law. There is nothing that prevents you from converting a family trust into a fixed trust. It doesn't trigger capital gains tax if you do it the right way. And frankly, it's because the taxation of trust rules are super busted and have been for about 15 years now. Anyway, we're going through all the risks, and I made it very clear to him that if the ATO saw this one, they would probably pick it up for a test case to litigate. And they'd also say that he has the resources to fight it himself. And I said, if you're going to go down this 0% tax route, you need to make sure that you have the funds put aside and liquid to pay for tax lawyers and barristers to fight this thing. We made a decision based on the risks. He was fully informed, eyes wide open. He decided on the 0% tax route. And I'm not saying this to say, look at me, I've paid zero tax for a client. I say this in the spirit of every client of mine is entitled to full and frank legal advice. I do not gatekeep these schemes. I say, here is everything that I think would be applicable to you, and the risks are fully explained. That's full and frank legal advice to me. And if I don't do that for the client, I feel like I haven't done my job. It's just like you go to the brain surgeon and they say, you're terminal, there's nothing we can do. But then later you find out they're running an experimental trial for some high-risk drug, and you would have taken that chance. People have sued in those cases. They said, you didn't give me proper medical advice. You didn't tell me all the options available. People in those positions will probably take those risks because they have no other options. But what the doctor does in that case is he takes that decision away from the patient by not giving them full and frank medical advice. And I give them the same thing. So if I say, you're basically screwed, there is nothing you can do, I'm dead serious about it. Make sure you follow for more story time.